Okay. Jefferson County Court at Law number 2 is in session. The court is in session with its announcement docket. When I call your name, please come forward with your attorney. If your attorney is not here, your attorney may be in another court handling another matter. And we'll wait for your attorney to arrive. If you are not represented by an attorney, or if you are representing yourself, when I call your name, please come before the bench by yourself. What is it? Oh, oh, who? We was resetting this, right? Who? Puma. Yeah, that's Miss Christy Carlton's. Might need to. It was reset to February 17th. Yeah, just have a seat. She said that. So that's Justine Pollard. Come on up. Miss Pollard, your attorney. Well, first of all, Miss Pollard, how are you doing? I'm doing fine. Your attorney is Mr. Tom Burbank. Attorney Burbank is not here because he's attending a seminar.
I am seeking other legal counsel.
Okay. Well, if that happens, then if you hire someone, your attorney that you hire, file what we call a motion to substitute. Okay? So if you're seeking other counsel, if you get another attorney, make sure you tell that attorney that you're currently represented by Mr. Tom Burbank. And what he will do, your new attorney that you hired will file a motion. It's called a motion to substitute counsel. And he will also contact Mr. Burbank to inform him as well. Okay? But until that happens, and until you come back to court, until the motion to substitute is granted, Mr. Burbank is still your attorney. Okay, so you need to stay in contact, Mr. Burbank and your bondsman. You're gonna get your case reset. What is that reset date?
March 6th.
That case is reset to March 6, 2026 at 9 a.m. You will get your reset from our court coordinator. Once you get your reset, you're free to go, and you have a blessed day. All right. Mr. White, this is cause number 25 CCCR 2256. Case is styled the state of Texas versus Jacorian L. White. And Mr. White, is that your full name? How are you doing, Mr. White?
Good, and you?
I'm doing fine, thanks for asking. Mr. White, the state is representing this case by Attorney Cornelius Williams. And Mr. Williams, how are you doing?
Doing well, thank you, Your Honor.
You're welcome. Now, Mr. White, you appeared here in court on November 4th of 2025. At that time, you filled out a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. And in that document, there's a set of initials on a line next to a box that state, I want to reset this case to hire my own attorney. And have you hired your attorney? Why haven't you hired an attorney?
The lawyer that I had tried to hire, he had said he was already working on my felony case, so he couldn't do it. Like he couldn't represent both. Can they do that?
Yeah. So he told you that
He couldn't.
he was representing.
No. The DA you had in here that day, like, I spoke with them and.
Oh, I see here at one point you said that you wanted to waive your right to an attorney
Yeah, to see.
and represent yourself.
Yeah,
And
he said he couldn't. He said he couldn't.
no, the district attorney doesn't represent you.
No, I'm not talking about representing. I'm saying he told me he couldn't like deal with it because it affect my other case that's up in here.
Well, I understand that. What he's saying is he could not make you an offer
Yeah.
on the misdemeanor case because you currently have a felony case.
Yeah, so Cause I'm not guilty, so I can plead
Well,
not guilty.
Yes, you entered a plea of not guilty. I understand that. So my question though is, why haven't you hired an attorney? You haven't had no time.
I'm not saying it like that, but I ain't have opportunity to do it yet. I've been working 12.
You must have been working at it 7 days a week since
7 days.
November 4th
7
of
days a week,
25th,
7 days.
November 4th of 2025. Okay. Now, let me do this. He has a felony case.
They all arose out the same set of operative facts.
What,
Judge.
when is this at?
February 11th.
Okay, so you,
They all have the same office.
Oh, let me ask you this. Hold on, you said February 11th.
yes,
You said next week I gotta go to felony court.
Next week. would be
It's February 11th.
So, I'm lost.
I'm getting close to asking for a drop.
Yeah,
Okay.
I'm guilty. Literally.
they said.
Okay, I understand you're not guilty. I mean, you entered a plea of not guilty, but my question, okay, let me ask you this here. Now, you don't have a lawyer in this case and you have a felony case. Now, his felony case is probably set for announcement.
Announcement, Judge.
Announcement?
In Judge Stevens' court.
Okay, we're gonna reset this case to that same date. Okay, February 11th. So on that day, you need to come here, check in with our bailiff. Then you'll go to the felony court. Once you finish in felony court, you're gonna come back here and let us know what happens. Okay?
Yes, sir.
So we're gonna keep these cases together.
I'm not guilty, and I'm just.
I understand, well, you entered a plea of not, I understand that. You'll have your opportunity,
See, I
to,
can't speak in Judge Stevens' court way.
okay, well, you'll have your opportunity to, defend yourself, in a trial. So, we're going to reset this case
To the same day.
same day.
All right, let me ask you one more question. All right, the lawyer asked for the motion to discovery. That's the video, right?
John West is a felony attorney, Judge.
Oh, well, yeah, well, whatever Wes is doing,
He don't even answer his phone. I've been calling him.
that's not my, put it like this here. It's like apples and oranges. He's in that court, not in this court, okay? So whatever happens in that court, in that case with your attorney, you may, now, you may have a different attorney in this court, all right? But your case is gonna be reset, give you time to hire your attorney.
So I still need to hire him.
Yeah, yeah, you didn't, you're not representing yourself.
How can I represent myself? I'm not
Okay,
guilty.
Judge.
Well, I understand
At
that.
this time, the state's gonna ask, given the court can observe the demeanor of Mr. Jacorian White before you now, Judge. When it came to a date, he said, when the date was mentioned at 11th, he wasn't aware that the 11th was 1 week ago from yesterday,
Okay.
Judge. As conditions of his release, if I'm not mistaken, he's not supposed to supposed to abstain from any intoxicating substances. With that, and given his verbose responses to this court, the state respectfully requests for a urine drop.
I mean, we can do that, but he still, has a right to represent himself. I mean, because that's what he's saying. He wants to represent himself. Is that right?
Guilty.
I understand. So what we're gonna do is give you an opportunity to, we're gonna give him the paperwork and he's gonna have to fill out the waiver of counsel. And then I'm gonna have to give you what is called a Faretto warning. Okay? And then we'll go from there. But in the meantime, you could have a seat in the jury box. Right there. Okay. The court is in session in call number 25 CCCR 1366, case is styled the state of Texas versus Derek D. Roundtree. Mr. Roundtree, would you please come forward? We're gonna reset Wilkerson's case. Mr. Roundtree, your full name is Derek D. Roundtree. How are you doing, Mr. Roundtree? That's good. Mr. Roundtree, you're represented in your case by your attorney, Attorney Langston Adams, who is appearing via Zoom. Mr. Adams, how are you doing?
Doing good, Judge.
That's good. Now, Mr. Adams, what is your announcement in Mr. Roundtree's case?
Judge, if you can just give me one reset, and if Mr. Roundtree can come to my office this Wednesday at 4 o'clock to look at his discovery, we'll be ready to go.
Okay. Did you hear that, Mr. Roundtree? Okay. Now, give us a reset date.
6.
This case will be reset to March 6, 2026. For an announcement. Give your attorney an opportunity to get with you to go over the discovery. Mr. Roundtree, you're gonna get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day. All right.
Thank you, Judge.
Stand
All
in
right,
front
see
of
you,
the
Mr.
court
Roundtree.
coordinator.
Yeah.
Okay, and you're free to go as well, Mr. Adams.
All right, y'all take it easy.
All right, you have a blessed day.
You're welcome.
Amanda Shelton.
Thank you.
Miss Shelton, how are you doing? I'm doing fine, thanks for asking. Now, Ms. Shelton, your attorney is Mr. William Wilkerson. Mr. Wilkerson's office contacted the court to inform the court that they will be applying for pretrial diversion on your behalf. And so your case will be reset. Once you get your reset from our court coordinator, you're free to go and you have a blessed day. And I think your attorney is currently unavailable. All right.
Thank you.
All right, you have a blessed day.
Judge, when you have the second,
April, this is the second week of April. above the line that is titled defendant, is this your signature? And on the next document, that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there is one box checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? I also have before me on paper a document that is titled discovery certification. Do you recognize this document? Is this your signature on the line that's titled defendant?
Yes.
Ms. Parr, before you sign and initial these documents, did your attorney go over these documents with you?
Yes.
Did you understand everything that your attorney went over?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Parr, are you a citizen of the United States?
State offer State Exhibit 1.
No objections? State exhibit number 1 is admitted. Ms. Parr, I see, thought it was one check, like you had. Another box on trial court certification is also checked. The second box that's checked states that this is that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes.
Okay. Now, Mr. Vasquez, you have advised and counseled Ms. Parr. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. Parr, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes.
Ms. Parr, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
And we'd ask the court for 12 months deferred adjudication. The state agrees to waive the fine for repayment of court costs, 24 hours of community service, and repayment of restitution in the amount of $2,307.33 to the Breakwater Bay Apartments.
Oh, because I wasn't changed.
What was that restitution amount?
It was $2,307.33.
Mr. Vasquez, were you appointed in this case?
Yes, sure.
What's the court cost?
The same.
Okay, Ms. Parr. The state is offering that you serve 12 months deferred adjudicated probation. During the 12-month probationary period, you will be required. Okay, you're not required to pay a fine in this case. However, you will be required to pay court costs in the amount of $277. You'll also be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll be required to reimburse Jefferson County Court-appointed attorney's fees, $350, and you will be required to pay restitution in the amount of $2,307.33 to the Breakwater Bay Apartments. Your total monthly installments, that is a total amount that you will be required to pay each month, is $350 a month. Are you able to pay the $350 each month?
No.
Okay. Let's see. That's $270. Do you have an affidavit of indigence on file? Okay, thanks. Okay, Ms. Parr, I have before me a document that is titled Jefferson County Affidavit of Indigence. I will hand this document to your attorney, and he will hand the document to you. Okay, Ms. Parr, have you reviewed that document?
Yes,
Is everything on that document still true and correct today? Or have,
my bills are still the same, but I'm no longer working at this job.
okay, so we need to strike through that. Let me see. Okay, so you no longer doing that. So to be,
Working call center, but our contract ended January 13th. So we wait on a new contract, couldn't get any job basically.
now let me ask you this here, Okay, Ms. Parr, the court is going to find that you're indigent. Based on the finding of indigency, not required, the state waived the fine in this case. However, you're required to pay $277 in court costs, and pursuant to Article 42.15 of the Texas Code of Criminal Procedure, it will be converted to, the court costs will be converted to 22 hours of community service. Attorney's fees in this case will be waived pursuant to Article 26.05 G-11 of the Texas Code of Criminal Procedure. The restitution amount of $15 will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. You will be required to pay the restitution in the amount of $2,307.33 to Breakwater Bay Apartments. You will also be required to pay your analysis fee you'll be required to pay the urinalysis fee of $15 a month. And you will not be required to pay probation fee in this case pursuant to Article 42.652, because the court finds that the payment of the probation fee in this case would cause you to have a significant financial hardship. So your total monthly installments in this case, that includes the amount for restitution and the urinalysis. Oh, I did that wrong. Hold on a minute. Recalculate it. Okay, so your total monthly installments in this case is $226. Yeah, $226 a month. Okay,
Thank you, Judge.
all right. You will also be required to perform 24 hours of community service. Now, the 24 hours of community service is in addition to the 22 hours that was converted from your court costs, so it comes to a total of 46 hours of community service. Do you understand that?
Yes.
You will also be required to adhere to the other standard terms and conditions of this probation. Ms. Parr, do you understand the state's offer and the findings that the court have made with the findings that you are indigent?
Yes.
Ms. Parr, do you accept the state's offer?
Yes.
And do you think that it's fair and it's just?
Yes.
And Ms. Parr, I'll follow the plea bargain agreement and with the adjustments that the court have made based on the fact that you are indigent. Okay. Now, Ms. Parr, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure where your record will be sealed to the general public. You can talk to your attorney about the non-disclosures because he's quite competent in those matters. Okay. Now, Ms. Parr, you're gonna have a seat in that first chair on the wall. Wait for your name to be called, and once your name is called, you'll be follow the directions of the bailiff. And once you finish following the directions of the bailiff, you're free to go, and you have a blessed day. And Mr. Vasquez, this is your only case. You're free to go as well, and you have a blessed day.
You as well, Your Honor. Thank you.
Thank you. Zaire Shelby. Oh, hold on a minute. Jefferson County Court at Law number 2 is back in session. Court is in session. 2 cases. They are cause numbers 25 CCCR 0632 and cause number 25 CCCR 0633. Both cases are styled the state of Texas versus Zaire Stephen Shelby. Mr. Shelby, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Shelby, you may put your hand down. How are you doing, Mr. Shelby? I'm doing fine. Thanks for asking. Mr. Shelby, you're represented in your cases by your attorney, Attorney Giles Cole. Mr. Cole, how are you doing?
Great, gentlemen.
I'm doing fine. Thanks for asking. And Mr. Cole, do you waive a record in Mr. Shelby cases?
Yes, sir.
Mr. Shelby, I have before me in cause number 25 CCCR 0632, a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Zaire Stephen Shelby, on or about February 6th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of fleeing a police officer. Mr. Shelby, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Shelby, how do you plead? Guilty, not guilty, or no contest?
No content.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Shelby, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. You recognize this document? On page 2 of this same document, there's a set of initials, ZS, on a line next to a box that's checked, no contendere, which means no contest. To place your initials on this document.
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Understand that statement? I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And Mr. Shelby, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct
Yes,
to the
sir.
best of your knowledge?
Yes, sir.
Mr. Shelby, are you a citizen of the United States?
Yes, sir.
State's office, State's Exhibit number 1, Your Honor.
Any objections?
No objection, states.
No objection. State's Exhibit number 1 will be admitted. And Mr. Cole, you advised and counseled Mr. Shelby. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Shelby, your attorney, Mr. Cole, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Shelby, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
The essential terms are as follows, Judge. It'll be 6 days in the Jefferson County Jail, time served, time actually served. All court costs and fees should be taxed and retired by that judge. And the number 25 CCCR 0633 will be disposed of and dismissed by Article 12.45 of the Code of Criminal Procedure, Judge.
Okay, Mr. Shelby.
Sorry, that correct, Mr. Code?
That's correct, John.
Okay, Mr. Shelby,
Yes, sir.
the state is offering that you serve 6 days in the Jefferson County Jail, but you will not be required to serve any more time in the Jefferson County Jail because you've already served 6 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not have to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. The state will be dismissing cause number 25 CCCR 0633 pursuant of a 12.45 Article 12.45 of the Texas Code of Criminal Procedure. Okay. Now, Mr. Shelby, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Shelby, I'll follow the plea bargain agreement that you have entered into with the state.
Yes, sir.
So he's not forfeiting the weapon.
No, sir.
Okay.
Yes, sir. Duly
Hold on.
authorizing with the
Yeah, hold on.
sir.
Let me take a look at it. Let me look at the facts.
As I recall, I'm sorry. You have the PC, Judge?
No, I'm pulling it up right now.
The firearm was found to be in the glove compartment. He's also was at the time, what is it called? Concealed carry permit. He had all that. The gun was registered to him. And I just don't see the substantive sins of justice justifying in this particular case, Judge. Yeah, unless I'm confusing this with another case, but I think that's it in this case.
Okay. Do we know his criminal history?
And do you, Judge?
Hmm?
Yes, sir.
And, I mean, I'm reading the facts. I'm reading the, this PC that,
If I do also recall, was it, it was either tent or license or
it was
something.
his license plate, his
Violations.
license plate was flapping. But when the police got behind him and started pursuing him, he started throwing stuff out of the car, right? That they didn't go back and find. They think they may have been drugs.
Or ice, Your Honor.
Ice. Okay. I'm thinking that the way I'm looking at pursuant to Article 18.19 D5, it says the court can forfeit a weapon if the court determines on the prior criminal history of the defendant or based on the circumstances surrounding the commission of the offense. That possession of the seized weapon would pose a threat to the community or one or more individuals. Okay.
Um,
And see another thing he did that it said the vehicle, the verbal registration showed it was not currently registered. Shelby would also did not have financial responsibility. Insurance on the vehicle observed the front left driver windows are visual dark. Oh, that's the dark intent used to park this issue.
It does show, let me get this so the court can have a full picture and I'll share it with you.
Yeah, I don't have, yeah. Yeah.
Okay. I'm looking at, I'm sorry. Wrong one. Does you want to pass this?
Pass it.
Yes.
We just hold on it. Just
Yeah, we can just pass it so I was looking at the wrong defendant on it.
So we got
Yeah,
one for the weapon.
we can, that's what I was going to discuss with you. I still want.
well, I mean, if he's going forward on this plea, he's already pled, court has already accepted it, right? Well, I mean, if he goes forward, the court is gonna be inclined to forfeit the weapon pursuant to Article 18.19 D of the Texas Code of Criminal Procedure, based on the facts and circumstances of this case.
Well,
Have a sidebar with.
Yeah, you can talk to him.
just pass for a moment, Judge.
Okay.
I was printing out the wrong,
Okay, so we're back on the record, and in this case, the court uh, the court accepted the defendant's plea of no contest in cause number 25 CCCR 0632, and it's 6 days Jefferson County Jail credit for 6 days already served. Court would tax and retire the court costs in this case because the time that the defendant has spent in jail has already paid off the court costs. The weapon in this case will be forfeited pursuant to Article 18.19 D5 of the Texas Code of Criminal Procedure. Because the court finds has determined based on the circumstances surrounding the commission of this offense that the possession of the seized weapon would pose a threat to the community or one or more individuals. Okay.
Just with the court, who should it be forfeited to? What law enforcement agency?
What
Sheriff's
agency?
Department, Beaumont Police Department, Judge.
Okay, so forfeited to the Beaumont Police Department. Okay, that's the agency. Texas, Jefferson County, state of Texas. Is this the police department? This don't look like a big Jefferson County. Hold on a minute. Yeah, Beaumont Police Department. And as mentioned, the companion case, cause number 25 CCCR 0633 will be dismissed pursuant to Article 12.45 of the Texas Code of Criminal Procedure. That is the order of the court. Okay. Just have a seat in the now. Hold on a minute. Let me accept something. Now, did you understand the state's offer? And do you accept the state's offer? Okay. I'll follow the people are in agreement that it's entered into with the state. Okay. Just have a seat. Wait for your name to be called. Once your name is called, you go to one that you be free to go and you have a blessed day.
Yeah, I get it.
Jefferson County Court at Law number 2 is back in session. The court is in session in cause number M333276. Case is style State of Texas versus Catherine Millie Furlow. Ms. Furlow, is that your full name? Ms. Furlow, would you please raise your right hand? Ms. Furlow, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Furlow, you may put your hand down. How are you doing, Ms. Furlow? I'm doing fine, thanks for asking. And Ms. Furlow, you're represented in your case by your attorney, Brian Matuska. Mr. Matuska, how are you doing?
Good morning, Your Honor.
Good morning. Now, Mr. Matuska, do you waive a record in Ms. Furlow's case?
Yes, sir, we did.
Okay. Ms. Furlow, did I swear you in?
Yes, Judge.
Okay. I swore you in?
Yes.
Okay. Now, Ms. Furlow, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Catherine Millie Furlow, on or about August 14th of 2021, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated while you were operating in a motor vehicle in a public place in Jefferson County, Texas. Ms. Furlow, do you understand what you have been charged with?
Yes.
To this charge, Ms. Furlow, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Are you pleading guilty freely and voluntarily?
Freely.
And are you pleading guilty because you are guilty?
Yes.
Ms. Furlow, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. You were supposed to check this box.
Oh,
Yeah, not the top.
what's that?
That's the DWI box.
Under the 1245.
1245. Becky talked about that. We just need to file that. You're gonna print him on the 1245, we're gonna file.
We don't have a no one. We actually do.
You're throwing around someone, because we tended it along with the people.
Right here, so-
Oh, here it is.
Okay. No, he got it.
Well, you don't have to do
Okay, now, Ms. Furlow, there's, I'm gonna erase the box that doesn't apply. Okay, now, the box says check states that this is a driving while intoxicated first offense. Do you recognize this document?
Yes.
On page 2 of the same document, there are a set of initials next to the box that says check guilty. Did you place your initials on this line? On the next page of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled discovery certification. You recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this, now, before you signed and initialed all of these documents, did your attorney go over these documents with you?
Yes.
And did you understand everything that your attorney went over?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
And Ms. Furlow, are you a citizen of the United States?
Yes.
State, you like to offer State's Exhibit Number 1?
So tender, Your Honor.
Any objections?
No objection, Your Honor.
No objections. State's Exhibit Number 1 will be admitted. Mr. Matuska, you advised and counseled Ms. Furlow. Is there any evidence that you are currently mentally incompetent to stand trial?
Absolutely not, Your Honor.
And Ms. Furlow, your attorney, Mr. Matuska, has advised and counseled you. Are you satisfied with his representation?
Yes.
Has he provided full, effective, and competent legal representation?
Yes.
Ms. Furlow, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
15 months deferred adjudication, Your Honor, 24 hours, community service. And a $150 fine, and that should run concurrent with F 21-38340,
Yeah,
which arose out of the same set of operative facts.
could you
This is
repeat that felony
Sure.
number again?
F 21-38340.
38. Repeat it again. F 21
dash
38340.
38340.
Okay, thanks.
Is that correct, Mr. Matuska?
Yes, sir.
And Mr. Matuska, were you appointed in this case?
I was, Your Honor.
Okay. What's the court cost in Ms. Furlow's case? $392. Okay.
This is, of course, where she's currently on deferred adjudication and the
Oh, she is?
the offense. Yes, sir, Judge. That's why.
Oh, okay. Okay, so she don't have to pay probation fee. And you're
That was the
announcing
intent
fee.
of the parties, Judge. Once again, correct, Mr. Matuska?
That's correct.
Okay.
Because we didn't. on this case.
Any question?
Yeah, you're right. These are very competent, celebrating. Fine man as well.
Okay. Ms. Furlow, the state is offering that you serve 15 months deferred adjudicated probation. During the 15-month probationary period, you'll be required to pay a fine of $150 plus court costs of $392. You'll also be required to pay a DWI conviction fine fee of $100. You'll be required to pay a reimbursement fee of $15. You'll be required to reimburse Jefferson County Court appointed attorney's fees of $350. You will not be required to pay the probation fee in this case because you're paying it in a felony case. And you will not be required to pay the urinalysis fee in this case because you're paying that in a felony case. Now, you will be required to pay Jefferson County DWI initial evaluation fee of $125 on the day of the police should a further evaluation be needed. You'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay in this case, is $72 a month. Will you be able to pay the $72 each month?
Yes.
You will also be required to install an interlock device on any vehicle that you own or operate, attend and complete a DWI education class, and have an alcohol assessment. Okay, I think you got to put the interlock on there. This is, you getting deferred, this interlock is mandatory. Okay? Now, do you understand the state's offer? And do you accept state's offer?
Yes.
And do you think that the state's offer in your case is fair and just?
Yes.
Okay, I'll follow the plea bargaining agreement that you have entered into with the state. I guess y'all can put that on here, the interlock. Okay, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Ms. Perlow, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record. And you may be entitled to get a non-disclosure. You get whereby your record is sealed to the general public. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. All right. Okay. Just have a seat. You're gonna stand next to the bailiff and follow the directions of the bailiff. Hmm? You say
Okay.
Hernandez? Daisy Hernandez? Oh, there she is. She's on this side, Mr. Boudreaux. This is cause number 25 CCCR 2156 case established state of Texas versus Daisy Marie Hernandez. Ms. Hernandez, is that your full name? Ms. Hernandez, you're represented in your case by your attorney, Mr. Don Boudreaux. Mr. Boudreaux, how are you doing?
Yes, sir.
And Mr. Boudreaux, do you waive a record in Ms. Hernandez's case?
Yes, sir.
Ms. Hernandez, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yeah.
Ms. Hernandez, you may put your hand down. Ms. Hernandez, I have before me on my computer a document that was filed by the Jefferson County District Attorney's Office. This document is titled Information. In this information, Ms. Hernandez, it alleges that you, Daisy Marie Hernandez, on or about May 31st of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of driving while intoxicated while you were operating a motor vehicle in a public place in Jefferson County, Texas.
Yes.
Ms. Hernandez, do you understand what you have been charged with?
Yes.
To this charge, Ms. Hernandez, how do you plead? Guilty, not
No.
guilty? You plead in no contest?
Yes.
Are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Ms. Hernandez, I have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes.
This document is also labeled as State's Exhibit Number 1. On page 2 of this document, there's a set of initials on a line next to a box that's checked no contendere, which means no contest. Did you place your initials on this document?
Yes.
On the next page of this same document, there's a signature above the line that's titled Defendant, is this your signature?
Yes.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes.
Is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yeah.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that's titled Discovery Certification. Do you recognize this document?
Yes.
Is this your signature on the line that's titled Defendant? Ms. Hernandez, before you signed and initialed these documents, did your attorney, Mr. Boudreau, go over these documents with you?
Yes.
And did you read and understand everything in these documents?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Ms. Hernandez, are you a citizen of the United States?
State Office State's Exhibit 1.
Any objections to State's Exhibit Number 1?
No, sir.
No objections. State's Exhibit Number 1 will be admitted. Mr. Boudreau, you have advised and counseled Ms. Hernandez. Is there any evidence that she is currently mentally incompetent to stand trial?
No, sir.
And Ms. Hernandez, your attorney, Mr. Boudreau, has advised and counseled you. Are you satisfied with his representation?
Yes.
Ms. Hernandez, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 12 months of deferred adjudication, a fine of $250, repayment of court costs, 30 hours of community service, the interlock device, and the standard terms and conditions of DWI first.
For the interlock, I've had it for almost 6 months, so I have to have it the full year.
That's the conditions of your probation. Let's see. This is 12. Mr. Boudreau, were you appointed in this case? Were you
Yes, sir.
appointed? You were? Okay. What's the court cost in this case? Ms. Hernandez, the state is offering that you serve 12 months deferred adjudicated probation. During the 12-month probationary period, you'll be required to pay a fine of $250 plus court costs of $392. You'll be required to pay a DWI conviction fine fee of $100. You'll be required to pay a probation fee of $60 a month, or your analysis fee of $15 a month, a reimbursement fee of $15. You'll be required to reimburse Jefferson County court-appointed attorney's fees, $350. You will also be required to pay Jefferson County DW Education an initial evaluation fee of $125. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month, is $182 a month.
For 12 months.
Yes, will you be, well, actually to be for 11 months because is the,
A job I got laid off.
you know, okay. Let me see her paperwork.
And
Affidavit.
he told me that I pay $40 a month.
Just hold on a minute. Let's see her affidavit of indigence. This is Miss Hernandez. Ms. Hernandez, I have before me a document that is titled Jefferson County Affidavit of Indigence. I will hand this document to your attorney and he will hand it to you for you to review.
Okay. I already have them.
Do you recognize that document?
Yes.
Is everything on that document still true and correct today? Is it still the same? Or there were some changes? And I'm basically looking at your income.
Oh, yeah.
It's still the same?
Yeah.
Okay. Thank you. Okay, let's see. Okay, Ms. Hernandez, the court is going to find that you are indigent. Let's see. Is that right?
Let me do this here.
Um, Okay, Ms. Hernandez. The state is offering that you serve 12 months deferred adjudicated probation. During the 12-month probationary period, you're required to pay a fine of $250 plus court costs of $392. That comes to a total, let's see, this is 6, that's come to a total of $642. The $642 fine and court costs will be converted to 51 hours of community service, and that's pursuant to Texas Code of Criminal Procedure 42.15. You also, now, the attorney's fees in this case of $350 will be waived pursuant to Article 26.05 G-11 of the Texas Code of Criminal Procedure. The reimbursement fee of $15 will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. The probation fee in this case of $60 a month will be waived pursuant to Article 428.652 because the court has found that the payment of the probation fee will cause you to have a significant financial hardship. You will be required to pay the DWI conviction fine fee of $100, and you're required to pay the urinalysis fee of $15 a month. So your total monthly installments in this case is $25 a month. Do you understand that? Now, you will also be required to perform 30 hours of community service in addition to the 51 that was converted from the fine and court costs, which comes to a total of 81 hours of community service. You will also be required to install an interlock device on any vehicle that you own and operate. You will be required to attend and complete a DWI education class. You're required to have an alcohol assessment, and as I mentioned to you earlier, you're required to pay Jefferson County DWI initial evaluation fee of $125 on the day of completion. For the evaluation be needed, you'll be required to pay an additional $25. And you'll be required to adhere to the other standard terms and conditions of this probation. Ms. Hernandez, do you understand the state's offer and the findings and adjustments that court have made in your case? And do you think that is fair and just?
Yeah.
Do you accept it? Okay, Ms. Hernandez, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Ms. Hernandez, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. Okay? Now, Ms. Hernandez, you're gonna have a seat in that chair. wait for your name to be called because they have to redo the paperwork. All right,
Thank you.
you're welcome, and you have a blessed day. Mr. Boudreaux, you're free to go, and you have a blessed day as well.
Thank you, Judge.
Okay, you're welcome. And we have Jacorin L. White. Hmm? Mr. White. Your full name is Jacorin L. White, is that correct? So White, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but
The
the truth.
truth and nothing but the truth.
Okay, so help you God. Okay, that's good. We're gonna be, now, Mr. White, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for court appointed attorney?
Yes, sir.
Okay. Now, I also have another document that is titled Affidavit of Indigence. Do you recognize this document? Yep. Okay, on page 2 of this document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes,
Now, before you sign and initial these documents, did you read the documents?
yes, sir.
Do you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Let me do this here. I'm looking at your affidavit. Okay. Okay. Okay, court is gonna find that you're indigent based on the finding of indigency. You're entitled to an appointment of a court-appointed attorney. An attorney that's gonna be appointed to represent you is Attorney Giles Cole. That was the gentleman that had just left, the tall black gentleman that just left. Okay, so he was next on the list, so he's appointed to represent you.
Can I ask you one question?
Well, hold on. Well, let me do this here before we're gonna get to that. Well, 2 CC 2256 25 CCCR 2257. Now, Mr. White, next issue that we're gonna go over. Court requested that you take a drug test,
Yes, sir.
okay? And do you have any idea what the results were?
You showed me the results.
Okay. So,
But if I take any other one after that, it's gonna be negative for everything.
okay, it's just gonna be negative,
But
but
I'm not the smartest man in the real way. I ain't trying to say positive. Yeah, negative.
okay, but it's not too smart to come to court smelling like marijuana.
I'm smelling like no, I come from my job. What I'm smelling like when you come to the.
Well, okay,
I swear to right.
Well-
I just raised my right hand in your court. I ain't smoked no weed. I've been at work since 2 o'clock this morning.
well, you can't say you didn't smoke weed because that's what
I ain't
that's what
smoking.
they found in your system.
Yeah, that's the only thing.
I know, you had to smoke it to get in your system.
Courtroom smell like weed. That's what I think.
Well, someone
That's a lot.
has told the court that you smell like weed. I'm not gonna come down there and smell you, but
You can come smell. That's why.
no, I'm not gonna
I've
do
been
that.
since 2 this
But you
morning.
tested positive, okay? And the court has bond conditions. When you get out of jail, you have bond conditions. They call them standard bond conditions. And one of the bond conditions is that, let me see those bond conditions. And these are standard bond conditions in all the courts, Jefferson County. And I'll just read condition number 2. Well, condition number 1 states that the defendant shall not commit an offense against the laws of this state or any other state or the United States. It's condition. Condition number 2 says the defendant shall submit to testing for drugs and alcohol at any time as directed by the court, and the court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. So you submitted to a test for drugs or alcohol, and the test indicated a presence of drugs or alcohol in your body.
Say THC on the paper. I ain't have no alcohol, nothing, everything.
That's a drug.
Yeah, I know. I know. I'm not trying.
Okay, well, I know what the paper said. I could read. and it-
You say alcohol.
I say drugs, alcohol, or alcohol, not and, drugs or alcohol. And so, so you violated your conditions of release, and based on that, the court is going to revoke your bond. Okay, which means that if the court, since the court revokes your bond, that means you're going to be taken into custody, and you're going to you have to go to the Jefferson County jail. Okay.
I don't know what it is. And then this, hold on, let me.
Well, hey,
I don't even
let me do this here. Okay,
good.
okay, Mr. Okay. Let's do this here, Mr. White. Mr. White,
You gonna be respectful, huh?
Mr. White.
I could go to jail for no.
Yes, you've been ready to go to jail for testing positive for drugs while you're out on bond. That's why you're going to jail. That is something. Okay, you saying it's nothing, it is something. Okay.
I swear to God, you could drug test me. Anything after this is gonna be negative. I don't
We-
smoke weed on
we-
a daily basis.
You don't have to smoke weed on a daily basis.
Just saying, I don't smoke weed at all.
Mr. White, you've been appointed a court-appointed attorney. Okay? And anything, now you have a right, you have an attorney, anything that you say can and will be used against you in a court of law. You have a right to remain silent. Okay? So just follow the bailiff and yeah.
No phone calls, no
Hold on. Just hold on.
Recess, so I can make sure you do reset.
Hey, we didn't tell you to leave. I say follow.
Give him his.
That's
Hold on.
Okay, just hold on. Just
So he could know who his attorney is. We had that issue before.
right.
So I need that paperwork from Jerry, so.
Okay.
This have been reset.
It's gonna be Giles Cole.
Yeah, but I still need to put his phone in.
Okay. This will conclude the calling of the court's announcement docket on the day's date, February 6, 2026, in County Court at Law Number 2 of Jefferson County, Texas. Judge Terrence L. Holmes presiding. Prosecutors, you're excused. Everyone, please have a blessed day.
Thank you.
Oh,